The Code of Federal Regulations on discipline began at 300.530, authority of school personnel. And as we discussed before, discipline is somewhat complicated, so if you need to get an attorney or you need to get an advocate, feel free to do so. We're going to go through the Code of Federal Regulations here, but if you need that help, sure seek it. The first thing under authority of school personnel is they need to make each determination on a case-by-case basis. That is, if the child does not have a disability, then they're just subject to regular discipline. If the child possibly does have a disability, or if the child does have a disability, then there's certain requirements they have to go through. And in general, if a child has a disability, then the school can treat them like a child without a disability and enforce the same disciplinary rules until they're out of school more than 10 consecutive school days, or actually it's 10 cumulative days also. So once the 10-day rule gets hit, then certain requirements are put upon the school to show that the actions by the student are not related to his or her disability. And so the key here to remember is the line, the bright line, is 10 school days. And during any subsequent days of removal, the public agency must also provide educational services to the child as required under their IEP. So what the school has to do is determine whether or not the behavior is part of the disability or not. And that's what this section talks about. While it's being determined whether the behavior is related to the child's disability or not, the child must be provided services, and they must receive a functional behavioral assessment to determine what else can be done, what interventions can be done in order to make sure that this behavior does not reoccur. As we stated before, if the removal from school is not more than 10 days, the suspension or expulsion, then there's no requirement upon the school. They can just treat it like any other case. If the discipline is going to be more than 10 days, whether it be a suspension or an expulsion, then a manifestation determination must be held. And that's a big word, manifestation determination. Essentially what it means is what your student did, what your child did, was it related to the disability or was it not? And that's what a manifestation determination is whether what your child did was impulsive because they have ADHD, or whether they have ADHD but it was carefully planned, then it probably wouldn't be related to their disability. But if it was just an impulsive action, it could be related to their disability. The two key questions are set forth right here. The first question is whether the conduct is related to the child's disability, and the second question is whether the school failed to implement the IEP, which then led to the behavior happening. So first of all, is it related to the child's disability or not? Second of all, was the IEP appropriately implemented? Those are the two questions that are asked during a manifestation determination. So if the behavior was part of their disability, then what has to happen? Well, first of all, the IEP team must conduct a functional behavioral assessment and return the child to the child's former placement, whether it was in the regular classroom, special ed, wherever, but return them to the regular placement under the IEP while it's decided where exactly the child needs to be placed and what modifications, if any, need to happen within the IEP. Now, Congress created some special circumstances where returning the child to the regular placement is not appropriate. And so a school can remove a child for up to 45 days, whether or not the behavior is determined to be a manifestation of the child's disability, that is related to their disability. And these are the special circumstances. The child carries a weapon or possesses a weapon at school, knowingly possesses or uses illegal drugs, or has inflicted serious bodily injury upon another person. And those three things are really pretty self-explanatory. If you have a gun at school, if you've hurt somebody fairly bad, and then if you have illegal drugs at school, all those things are going to get you out of school one way or the other, whether you have a disability or not. It's just a zero tolerance. Now, that doesn't mean that services shouldn't be provided to your child, and we'll talk about that a little bit. The placement of your child during the 45 days of the interim alternative educational setting is determined by the IEP team. So you'll have an IEP team meeting. They'll determine where services should be delivered during the period that your child's out of school. Remember, once again, your child's still entitled to services under the IDEA. Section 300.5832 talks about appealing the decision of a manifestation determination. Now, either a parent can appeal it, or also a school district can appeal it. And so this is one of the few occasions under IDEA where the school district has a right to go ahead and appeal also if they figure that the child could be a danger or try to hurt somebody else, or they have serious concerns. They can always ask for an appeal. You also, as a parent, can ask for an appeal if you just think that the decision was inappropriate. For the procedures and how to go ahead and file an appeal, look down at our section on due process rights. There's a section there on requesting a due process hearing. Go ahead and take a look at that, and that's where you can do that at. If an appeal is asked for, it's often expedited. This is because Congress felt that let's keep children with disabilities as little as possible out of school, try to keep them in school as much as possible. So generally the hearing happens within 20 school days unless there's an extenuating circumstance, and then a decision's issued within 10 school days. You're still talking a long ways out, about a month and a half. You can also go to mediation to discuss the issues, but that will delay the decision, can delay the decision even farther. Now, section 300.534 is for children that have not yet been determined eligible for special education. The key point here is if the schools knew or should have known, according to the records, that the child possibly had a disability, then there's certain requirements upon the school to take a look at that. They just can't unilaterally, well, they can remove the child for the time being for safety reasons and stuff, but they do have to address on why they didn't provide services to the child under the IDEA. Now, what would be the conditions under which the school knew that the child may have a disability? If the parent of the child expressed concern in writing, if the parent of the child requested an evaluation, if a teacher or other personnel of the school expressed concerns about behaviors that were demonstrated and that was never addressed. Then what the courts are saying is that the school either knew or should have known that the child, that this was coming down the road, and so that it should have been addressed through an identification evaluation process and possibly an IEP and services and a behavior intervention plan being put in place. And so this is for children who have not yet been identified. So there is some occasions where you can go back and access the IDEA protections even though a child previously wasn't identified for IDEA services. Finally, here at the end of this section, we've just included some things that are extra. They're beyond the IDEA. They apply to the IDEA, but this is just for your own information. One is that any state law, IDEA does not override state laws involving any criminal actions or judicial actions or state enacted laws, that those can still be carried through. So let's say that a child takes a gun to school, is charged with a crime. IDEA does not override that crime even if the child is found to have a disability. That's up to the state. We've also included a definition of removal from a regular classroom setting or a regular education setting or special education setting, but removed from regular services. That occurs when there's more than 10 consecutive days, and as you've seen before, that's all it said was 10 consecutive days. But the courts have interpreted that to say if there's a series of removals that constitute a pattern, or there's a series of removals that add up to more than 10 days, that's cumulative, then also the IDEA protections for being expelled from school or suspended from school over 10 days kick into play. We've included a couple of definitions just for your own use. One is on serious bodily injury. These are things that override IDEA. And we've also included a definition of a dangerous weapon. It's important to note that this length here of a knife is 2.5 inches, not 21.5 inches or anything like that. But this is just a definition of a dangerous weapon. That is the federal regulations on discipline. Take a look at them. Like I said, if you do need an attorney or an advocate, feel free to contact one. We have contacts in our contact section. And that concludes the Code of Federal Regulations on discipline.